this ordinance committee meeting of August 23rd to order. Madam Clerk, may we have a roll call, please?
I just want to correct the date that it's August 29th, not the 23rd.
Okay,
That's
thank
okay.
you.
That's okay. Councilmember Jordan.
Here.
Councilmember Sneddon.
Here.
Chair Oscar Gutierrez.
Present.
Thank you.
Are there any changes to the agenda?
No changes to the agenda.
Okay. Do we have any public comment that's not, or for items not related to the agenda?
Chair Gutierrez, we do not have public comment.
Okay. May you please read our first agenda item?
Our subject today is municipal code cleanup amendments relating to peddling, soliciting, and vending on public and private property.
Thank you. May we have staff report, please?
Afternoon, Ordinance Committee. Assistant City Attorney John Doimus. I am joined here with my esteemed and wonderful colleague, Dan Henschke, and we are here to jointly present a couple amendments to different chapters in the Santa Barbara Municipal Code as it relates to peddling, soliciting, and vending in majority of public but also private property. So the three chapters that we are talking about today and have made changes to are chapters 5.32, 9.48, and 9.49 of the Municipal Code. Just a brief overview of these chapters. Chapter 5.32 deals with soliciting and peddling, which includes private property and the licensing program for that. When we talk about this, we're talking about people peddling door to door, et cetera. That's what that chapter deals with, not sidewalk vending. 9.48 deals with commercial use of city streets, and while the newly drafted about a year and a half ago, chapter 9.49 regulates sidewalk vending in the city. Our recommendation first is dealing with the least complicated work product was repealing chapter 5.32. And there's several reasons for this. First of all, this ordinance was originally drafted in, I believe, the late 1960s, early 70s. And since that time, there have been case law that have rendered a lot of this municipal code section unconstitutional. Mr. Henschke can also go on to discuss that during his portion of the presentation. And additionally, while that chapter does require peddlers who are going door to door, et cetera, to have license, as you can imagine, that has not happened for potentially decades, and there's no enforcement on this. So it'd be horrible to have an ordinance that's on the books that's really not really being dealt with or enforced. But the most important provision of that chapter is dealing with the basic issue of trespass. When a property owner, whether it be commercial or residential, has a sign saying no solicitation, et cetera, that would be a violation. And so we moved that section, since we're repealing 5.32, we moved that particular portion and violation into chapter 9.48. Now we're going to discuss mainly 9.48, 9.49, but we wanted to provide a brief reminder in terms of kind of the limitations of these ordinances. As you may recall, in 2019, SB 946 became effective, which enabled cities to regulate sidewalk vending, but they had to do so as long as there were health, safety reasons and welfare concerns. Cannot be for economic reasons, and it would be time, place, manner restrictions. Also, it prevents cities from criminally filing charges against someone for the act of sidewalk vending. And as I said, the basis for these amendments now on 9.48, 9.49, there's a couple, right? One is to assist code enforcement for violations. You also may recall that when we did pass the sidewalk vending ordinance, we wanted to do 1 year of outreach before we began actually enforcement. So we did that in terms of educating, providing outreach. Staff did a wonderful job on that. And as we've begun enforcing on the ordinance since March, we noted some issues that kind of needed a little cleanup to help with enforcement that we'll explain. Mr. Henschke now will go into changes then 9.48 and 9.49.
Thank you, Honorable Chair, members of the committee. What I want to talk about today is why did we, first of all, why did we make these amendments and why are we recommending them to you? As Mr. Doimus indicated, in our review of the existing code, we determined that there were a number of provisions that, in our opinion, don't meet current legal standards for activities such as solicitation. In many contexts, solicitations are First Amendment protected activities, and many of our existing regulations were such that they were susceptible to challenge, and the last thing we want to have right now is additional expenses addressing legal challenges to these ordinances. So we sought to clean up all of the existing provisions that really govern solicitation on city streets and sidewalks, including the peddling restrictions. With regard to Chapter 9.48, that's where our basic prohibition against doing business on city streets and sidewalks, city buildings, city parks, city paseos is contained. So we went through the process of evaluating that section. The First Amendment that we made, or suggesting we make, is to the general prohibition itself. And right now it talks about using streets and sidewalks for these commercial purposes. Use is a very nebulous term, and it is susceptible to challenge. So we made amendments to the ordinance, to the code, that would talk about occupying. And we define occupying to basically remaining in a single location for the purposes of engaging in specific types of commercial activity. That is, and if you recall, this is very similar to the same reasons that we have other ordinances against the occupancy of a sidewalk for purposes other than transportation, such as our sit-lie ordinance, that kind of thing. So that's the first change. We also went through and we cleaned up the ordinance by removing sections that are essentially duplicative of other provisions in the code where they're dealt with more specifically. And so what we recommend doing is including a list of all of the cross-references. We've done that, and then we've just eliminated, in this particular section, the exceptions to the general rule. In addition, we added in a provision, which is basically an anti-fraud public protection provision that requires anybody who's using the sidewalks and occupying them for the purposes of vending to have a valid ID card, valid government ID card. That there's a legitimate government purpose behind asking somebody who's using our sidewalks for these purposes to identify themselves when asked by law enforcement to do so. And finally, because oftentimes when you occupy the street or sidewalk, you might be using facilities to do so. If you are using facilities in violation of the ordinance, we can abate those, the equipment, and there's a procedure that we've established in the new ordinance to abate by seizing and then allowing recovery of those that equipment and other instruments of doing the work later after the nuisance that is caused by having the thing in the sidewalk is abated. We've also made changes to Chapter 9.49. That's our sidewalk vending provision. We clarified the definition of sidewalk vendor to make it more consistent with the state statute. We also made it clear that if you don't meet the requirements of a sidewalk vendor, in other words, you're not complying with all of the regulations, you're not a sidewalk vendor, and you're not allowed to occupy the sidewalk for the purposes of vending under Chapter 9.48. And so 9.48 establishes the general prohibition. 9.49 establishes an authorization for sidewalk vendors, but if you're not a sidewalk vendor, it's prohibited activity. And then because of issues that have come up with regard particularly to food vendors, we made it very clear that the sidewalk vending carts have to be self-contained, which was already in there, and that the cooking facilities for a vending cart have to be contained within the cart itself. So that concludes my portion of the presentation. And now I would be happy to answer all of the list of questions that our presentation probably gave rise to.
Thank you for that report. Now I'd like to open it to my colleagues. I see Mike Jordan has some.
I'm in, of course. I'm just going to go through my list because I just kind of walked through and made notes, and I know I don't really have a grasp of that last explanation that you had, general prohibition, and then qualifies or not, so just forgive me if I'm overlooking at one of them and not the other. So how do you handle a parkway? Is that a street or a sidewalk? So somebody's over somewhere and there's a sidewalk there, but there's a street being used, but there's like a 6-foot parkway of dirt, and somebody sets up in the parkway. Is that handled somewhere in both of these, or either of these?
Honorable Chair, members of the committee, in a word, yes.
Okay.
And it's found in basically the general prohibition talks about public streets, parking lots, street furniture, public buildings, public parking ways, public right-of-way, public sidewalks. So the parkway is part of
Okay.
all of those things. And then in section, chapter 9.49, dealing with sidewalk vendors, we talk about where they can be located.
Okay,
And so that is addressed.
okay. If you say yes, I'm going to believe you, okay? So you don't need
I'll
to.
stick to the short answer from now on.
That's okay.
Unless
Just I don't
necessary.
take up all the time. And then the driver's license requirement. So I just have a list of examples. Something that's not a street, not a parkway, might be a park. It might not be a park, but it's public land. And then it's De La Guerra Plaza at Fiesta. It's just off of De La Guerra Plaza at Fiesta on State Street or Stork Placita. Do all those require the people operating, those examples require the people operating in those functions to be able to produce a ID that we can identify them?
Honorable Chair, members of the committee, yes, with an explanation. The card that's required is some kind of picture ID. Doesn't have to be a driver's license, could be some other kind of government-issued identification. With regard to many of the vendors that you were talking about, those are licensed and permitted activities, and so within the scope of that license or permit, the specific obligations for that particular activity are contained.
Okay.
The general prohibition is that if you are out vending and you're not operating under one of the specific licenses, you have to have that
You have to be able to
ID
identify
card in your
yourself.
wallet
Yep.
someplace.
So if somebody like snuck in on a fringe of Fiesta that wasn't part of Fiesta, boom, they're our process, not the permitted group.
Honorable Chair, members of the committee, yes.
Okay. Then I think I'm ahead on my answers, but my example is going to be, I think you mentioned it earlier, the occupied definition. You're in one place for a period of time. What happens to a strolling vendor? I've seen strolling vendors at parades or whatever, and they're definitely selling and they're definitely not occupying. They're on the move.
Honorable Chair, members of the committee, you've identified one of the constitutional issues that we were seeking to avoid in adopting the new ordinance. Solicitation activity is essentially oftentimes speech activity. Those kinds of individuals who are, I'm going to call them itinerant vendors walking on the sidewalk, come within the scope of the sidewalk vendor, and those would be authorized to act, to do their activity under our existing regulations, 9.49. Even if they weren't authorized as a sidewalk vendor, the courts have held that simply using the street and for solicitation and vending purposes has constitutional protections. That's why we changed from the word use of the street or sidewalk to occupy the street or sidewalk, and then defined it as remaining in a specific location, because that kind of basically taking over a portion of the sidewalk has a greater public interest in regulation than simply walking up and down the street trying to hawk watches to unsuspecting customers.
So we're still kind of out of luck there, is
Yeah.
what you're telling me?
Yeah.
Okay. How about a street musician on a sidewalk with a obvious dollar collection receptacle out in front of him, him or her? Does that qualify to be regulated under this?
No, honorable chair, members of the committee, that is not a sale of any particular good or service. That's playing money and asking for donations. And again, that's a First Amendment regulated activity, that's a First Amendment protected activity. If we want to regulate that kind of activity other than under our current noise amplification laws, which is what we do, we would need to adopt specific regulations dealing with street musicians, which we don't have right now.
Okay. And all my questions are really down in the nuts and bolts of this. The vending part of it that relates to retail, I think said, has to be out in front of a retail establishment. I might be paraphrasing generally, that if you had a retail location, they were because they already have a business license, they could set up sidewalk or street without whatever any of the other complications are, but they would have the ability to set up in the sidewalk or street and just piggyback off their retail operation adjacent to them, right in front of them, right?
Honorable Chair, members of the committee, that's basically correct, and that is part of the existing code that we are not recommending be changed.
Okay. So I guess my question would be to maintain flexibility in where we are, where we think we're going to be, or what logistics we're dealing with. Some retail stores or retail stores of the future have those obscenely big planters out in front of them if they wanted to get out on the street, and they would have to maybe scooch over in front of an adjacent closed bank building on the weekend. And so how do we, I guess my question is, how do we live with that language, whether existing or not, and be in a position to allow the greatest flexibility for use of the empty landscape that's down there when a person can't necessarily get right out in front of their retail? They might have to move two frontages over, or why do they need to? Can they not go across the street so they're in the shade or something most of the day?
Honorable Chair, members of the committee, you seem to be suggesting a circumstance that applies to a particular neighborhood in the city that we've referred to as the State Street Promenade.
That would be it.
And that is being regulated separately. This particular ordinance applies citywide. Could you potentially authorize that kind of activity in a broader area than is authorized under the current code? You potentially could. We would have to evaluate that. It is not part of the current recommendation. And the scenario about the sidewalk sale is part of the existing code that has been applied for years. And if you want us to change that, you would need to give us direction to investigate that.
Okay. So talking about whether, not your roving people, but your people who would qualify under the existing or changed code to be on a sidewalk and insist upon setting up on a sidewalk during a permitted event. So say solstice on Anacapa in the middle of the parade, and somebody gets there at 5 o'clock in the morning and wants to set up a a vending, peddling, sales thing on the sidewalk, but clearly by noon, that's just a mess and a mayhem of people, and we want, I guess I want people on the sidewalk rather than a vendor on the sidewalk. Does that permit protect us to get those people out of the way so that spectators can be there and there's no support or recourse in the ordinance to allow them to insist that they can stay there?
Honorable Chair, members of the committee, my recollection is that the existing provisions of Section 9.49 relating to sidewalk vending preclude would preclude a sidewalk vendor from operating within the area of a special permit,
Okay.
special permitted activity like that. So, yes, we could make the move along. In addition, permanent sidewalk or stationary sidewalk vendors are not allowed in those areas.
And then, I think I'm pretty close to the end. The private property stuff, so prohibition of peddling and soliciting on private property in violation of a posted sign. Why does the poor property owner have to post a sign for peddling and soliciting? Why is that not just automatically trespassing if somebody's there without approval?
Honorable Chair, members of the committee, the best answer I can give you is because the United States Supreme Court said so.
I can't go higher than that? No, okay. Can
Not
we figure out a way to combine that with the, I'm not there, but you're trespassing notice, so it's one notice? You know what I'm talking about? That you use so that if the business is closed, there's people camping on your front porch, the police can come by, and if you have that posted notice, they are allowed to move people off of private property. Can we there's a template notice, the DO pretty much facilitates that, but can we work on combining that so it's like one notice posted on the window that contains both the specific language for the in absentia trespassing, but also in absentia peddling and soliciting on someone's property?
Honorable Chair, members of the committee, the two notices perform different functions, but could a single sign accomplish both purposes? I can't see any reason why not.
If I may add too, as well as that, yeah, one issue deals with violation of the penal code, while this issue deals with violation of municipal code. So there's nothing wrong with, like, as Mr. Hensky said, of having, working out a template where at least both regulations, penal code and municipal code is placed on that.
Yeah, it's ornery to have to tell every year to make those guys get the stuff back up, make sure it's up, keep it up. It looks so terrible in the window, and pretty soon you're adding like 27 signs up there just to
Honorable
protect
Chair,
your property.
If I could address this additionally, you'll go around cities all over California, all over the country, and see the no solicitors or peddlers or something similar on doors. The reason for that is that's what you need to do in order to enforce an ordinance like we're proposing.
Okay. And then last question, I'm sure it is. In regards to anything that's food handling that requires a permit or a certification from the county, does playing with these ordinances allow us to shut something down if it's not operating lawfully, if the lawful component is someone else's certification or permit? So they're in the right place, they're doing the right thing, they meet all the bells and whistles in this, but they don't have a, I don't know what I'm talking about. They don't have a food handling or food prep or food storage certificate. They don't have a sink, they don't have fresh water. I mean, you could just do like 5 bullets probably. Does that allow us to use these ordinances to shut them down because we know they're operating illegally on city property?
Honorable Chair, members of the committee, these regulations don't deal with that issue directly. If there is a violation of a health permit, that has to be enforced by the agency that's authorized to do that. We do have the ability in some instances, for example, if there's a violation of the fire code at a particular location, to cite for or arrest for a violation of the fire code. But these ordinances are not designed to make a determination of another illegality and then use this ordinance as a basis for shutting down. It's just, they're not designed to do
I want to
that.
fall into my toddler mode and just go, why? Why not? What prevents it from, I mean, I get it, we haven't done it that way in the past, but is there something that legally prevents us from doing that?
Honorable Chair, members of the committee, I think that the problem that you get is one of evidence and proof, because we can't necessarily turn our enforcement officers into experts on county health laws. In addition, there are state laws, particularly dealing with sidewalk vendors, that make enforcement of the health rules with regard to the sidewalk vendors infractions as well, and they're preemptive. So there are preemptive provisions relating to enforcement of the health laws, but we don't,
Okay.
well, as a practical matter, we really can't do that to and
My
make
dumb,
it
my
enforceable.
dumb analogy would be I have a driver's license issued by the state, but we must be given authority to regulate me or cite me for having or not having a driver's license. We don't have that pathway from the county to the city to be able to do that.
The state has given us the authority to enforce if you're not driving with a license.
Thank you so much. Thank you, Mr. Chair.
Thank you, Councilmember Jordan. Councilmember Sneddon.
Thank you, Chair. I have some follow-up questions along the lines of Councilmember Jordan. I mean, we've all gone to meetings where we've heard issues related to health, safety, welfare, not just of the community, but of the workers themselves. And I'm just wondering if we have an opportunity here to be addressing worker trafficking, human trafficking. You know, if the vendor themselves doesn't have an ID, what happens? What happens next?
Honorable Chair, members of the committee, I don't know what happens next. But the scope of our sidewalk vending regulations, which is really what you're talking about there, is dictated by state law. And our regulations are as much as we can do under state law, which is preemptive. But we can't use it to enforce human trafficking or immigration or other kinds of laws.
So if just, there are a couple different ones I want to just kind of play through the scenarios. What happens? There's an open fire, or using a generator, or the food is not contained within the cart. That's one type of thing. And then you go up to the vendor and you say, do you have an identification? And there's no identification. What, is it in this ordinance, or what is our mechanism then? Do we still need to notice and then wait? And then if the cart is moved, then, you know, is this an opportunity where we could address that, where if there's a fire safety or a safety issue for the vendor themselves? Like, what happens with that cart?
Honorable Chair, members of the committee, that's a really good question. Let me try and break it down into a couple of different parts. With regard to the identification of the people doing the activity, that is the reason why we are adding in a provision for all vendors to provide an identification, and that's part of the amendments that we're making. The other has to do with a violation and the ability to remove the equipment that is causing the violation, or is being used as an instrumentality of the violation. We already have that ability with regard to or chapter 9.49 with regard to the carts. We're adding it in for other types of activities, and that's the provision in section 2 of the ordinance, which adds 9.48.020B, that's in there. With regard to the fire violations, we can enforce those as a function of our fire code. That's a safety violation, and that is really regulated under our fire code and not under these specifics.
So under that, it's not immediate, is it? If there's a fire violation, is it an immediate shutdown of the operation?
Yes.
Okay. And so the ID question, I'm just, what happens to a person who doesn't, like, what's the penalty for violating? And are we going to be penalizing people who don't have IDs? And what would that penalty be? That's, I guess, my question about what happens next. You come across a cart, there's someone operating it without an ID. What happens?
Honorable Chair and members of the committee, I'm going to let Mr. Doimus answer that because it really does relate to police and enforcement.
Absolutely. Thank you, Mr. Henschke. And Councilman Jordan, before I go into that, yeah, a lot of these issues deal with jurisdictional. So exactly, if you have a health violation, that's why we have county health to deal with that, because we don't have the jurisdictional issue. To answer your question directly, Councilmember Senden, as you know, we cannot criminally charge anything in terms of this, the enforcement. But what happens is the failure to produce an ID, because we need to have an ID, as Mr. Henschke said, is you're using the commercial streets, it's a reasonable expectation to produce, is that we can then abate it. It's a violation, and we can put a stop to the vending act and continue to do so until they do get a proper ID and are able to furnish their true identification on that. So we're able to, prevent and ask them to pick up and leave. We were able to, if potentially, if, we're a scofflaw and refuse to cooperate, is to, and as you see in one of the new sections we added, able to take in the equipment, which we could hold for 60 days is the limitation on that. So that would be the immediate response. So that's the portion that what allows us to do is immediately stop the activity. Can't criminally charge it, but we can abate that violation until the ID is presented.
Thank you, and I think that's what I'm getting at. Just to be clear, I would not want the operator themselves to be arrested or criminally treated, but more the equipment itself could be removed.
Correct, and that's that we would be following state law on that.
Okay. And then, thank you. And then so food safety is through the county. So if there's, warm meat left out and transported in plastic bags, that kind of thing, that is a county health violation, and that's that jurisdiction. I just want to make sure that that's correct. Anyone?
Honorable Chair, members of the committee. Yes.
Okay. And then what about, I'm just trying to hit on the issues that have come up. What about waste left behind or that is not contained in the cart or near the cart, either human waste or waste associated with the operating of the cart?
Honorable Chair, members of the committee, our current regulations require the operator to have sufficient waste capabilities for their cart and to remove all the waste and to pick it up. In terms of the abatement of other waste on our sidewalks, can we make the vendor go out and clean all the other stuff up? I don't really think so.
Okay.
And it's a problem that we have to address through other means as part of our street maintenance program.
Well, that's what I'm wondering, if this is an opportunity, and I don't know what the mechanism would be, but it's clear that vendors are there for 8 hours, no access to a restroom, not necessarily access to hand washing stations. So it's, can we, I guess we can't require that, but how do we address that?
Honorable Chair, members of the committee, with regard to the sidewalk vendors, for stationary sidewalk vendors, they have to be located in certain specific areas within the town. You can't just go set up for 8 hours without meeting the locational requirements under the ordinance, and you have to have your facilities. Now, granted, there are facilities that are being operated by persons that are out there now that are not sidewalk vendors, they're not using a cart, they're using a pop-up tent and a table and a whole bunch of different things. That's one of the reasons why we're putting in the provision in the code that says, if you're not a sidewalk vendor as defined, is that you're not vending either from your person or from a cart, as we've defined it in the code, then it's prohibited activity.
Okay.
And then we can stop the prohibited activity, and we can remove all the facilities. Now, your question was, can we make them pick up all the stuff around there?
Or their own stuff.
Their
Not
their
other
own
people's stuff.
yes, but not other people's stuff, and we would abate it.
Okay. So then this would take care of, say, on the promenade, someone comes in and sets up a whole cooking hibachi style in a tent and is basically setting up a mobile kitchen and serving. This addresses that activity.
That activity would not be permitted within the promenade.
Okay, thank you. And then, what about Girl Scout cookies? It's a hyperbole, but, Girl Scouts set up a table, they're selling, vending. Do they need a business license or a permit, or they can just do that? Can anybody do that?
The honorable mayor, members of the committee, if the Girl Scouts were setting up on the sidewalk or on public property, they would either need to have a permit, or they would be a sidewalk vendor subject to the sidewalk vending regulations.
Okay. Okay.
And if I would like to add, that's why in many cities too, you usually see Girl Scout cookie at a grocery store or private commercial property, because then this would not apply. And if the business owner at a commercial mall wants to let them set up there, it's a non-issue. This ordinance wouldn't apply.
And then for the downtown organization, when they have those sort of activation nights and they have a bunch of vendors out, that's permitted? And
Yes.
then people are under that organization sort of event?
Honorable Chair, members of the committee, yes, that's already part of the existing regulations, and that would be carried over into this. And we already allow cascarones specifically in our Chapter 9.49, so we don't have to worry about those.
Good. Okay, thank you. And then back to soliciting, what is the penalty for soliciting? If there's a no soliciting sign and someone knocks anyway, and I'm not suggesting we enforce on this, but just sort of what is the penalty?
Honorable Chair, members of the committee, all ordinances of the city are enforceable by either as a misdemeanor or as an infraction. And most of the time, we would enforce as an infraction. If it's an urgent situation, a misdemeanor violation could be pursued. And that's what we have for all of our municipal code violations. Sidewalk vending is only an infraction.
Okay, thank you. So then there's just a situation where there's a telecom, I don't know, it's Frontier, and they go around and they go door to door soliciting business. If you have a sign up that says no soliciting, they can't knock on your door?
They are not supposed to knock on your door, and if they do and they try to sell you something, that would be a violation of the ordinance.
Thank you.
Yeah.
And then this question has come up, is political canvassing soliciting?
Honorable Chair, members of the committee, no.
Okay. And then one more question. So you've had the year of education outreach. how's it going? Is it well received? Do people say, oh, yes, okay, now I understand, I'll do what you're asking? Or is it, how successful has that been? And what are kind of lessons learned or things to consider?
Honorable Chair, members of the committee, I would have to defer that to Ms. Anderson.
And this is my last question.
Good afternoon, Honorable Chair and Councilmember Sneddon. Mr. Harris was responsible for the education and outreach as it relates to the sidewalk vending task force prior to me being assigned to facilitate that task force, as well as the enforcement team and the education team. So I can speak to that communication was happening, not as concerted as what we've been doing lately. And that education has crossed all departments. So where the vending is occurring, the staff has been responsible for communicating what our guidelines are. So far, we have received a level of voluntary compliance. So if they're in the public right-of-way and they need to move out of that public right-of-way because they're blocking it, they readily move. We have been focused more on enforcement of the vendors that do not fall within the sidewalk vending ordinance. And today, if the ordinance committee recommends going to council, that's exactly why we're looking for more definition there. And so our education teams are being created in full force, both English-speaking staff as well as bilingual-speaking staff, to share more of our guidelines. The smaller vendors that operate in a way that don't occupy the public right-of-way, that don't use open flames, their food handling is in or could be in compliance, we will actually make much more of an effort to give them warnings rather than notices of violations prior to moving forward with that enforcement step. So we're actually going to do, to answer your question, another round of education and outreach to all vendors that could be in compliance with our ordinance.
Thank you.
Thank you, Councilmember Sneddon. I have a few questions. Will this counter any federal, state, or county laws that we have if we implement this?
Honorable Chair, members of the committee, in our opinion, no. This will be consistent with all applicable state and federal regulations that would be preemptive.
And how would this affect things like child labor? Is there a loophole if it's a child that's somebody under the age of 18 that's being the solicitor?
Honorable Chair, members of the committee, quite honestly, have never thought about it in that context, but it applies to all persons. And so a minor who was violating the provisions would be subject to enforcement activity. The enforcement against juveniles is totally different than enforcement against adults. Do we have a provision in here that says if you're under 16 or under 18, you can do it? No.
And then I would like to add, remember, Councilmember Gutierrez, we also aren't going criminal, so it's mainly administrative. It'd be a lot of outreach, and it would be for the abatement to stop the action. But that's one of the things that at least we're limited by state law, and, we don't have to worry about that issue because we aren't going criminal against anybody.
Okay. Yeah, I'm just worried that certain people will exploit that. So maybe if we can research a little bit more into it, that I feel like would be helpful. Also, how does this affect nonprofit organizations that are going to be soliciting in public spaces, not private properties? Because I know that obviously the Girl Scouts, that's a nonprofit, but they tend to set up on private businesses or private property. But there are other nonprofits that do like gift wrapping or things like that. Like, does that change how this would affect that?
Honorable Chair, members of the committee, that's a good question. In terms of simply nonprofit solicitation of donations and nothing more, we don't regulate that activity. That's protected by the First Amendment. What we're really talking about is activity that is akin to any kind of selling or vending, commercial activity. For example, solicitation of a donation in exchange for the provision of a good. That's akin to a vending transaction that would be covered, and it would either be prohibited if they were occupying, unless it was authorized by some other provision in the code. And in the context of just straight non-commercial solicitation, we don't regulate that because of First Amendment issues associated with it.
Okay. And I suppose that also goes to religious organizations.
Honorable Chair, members of the committee, that's correct.
So theoretically, if a religious organization or nonprofit were to have children soliciting, the consequences would not be the same for some adult who's doing it for private benefit.
Honorable Chair, members of the committee, the ordinance is aimed at specific kinds of commercial activity. In terms of who does the activity, we're not regulating that, and I don't know how that we really could. The child labor laws and those kinds of things are different laws that are established by either the state or federal government. We don't regulate that kind of activity. I don't think we really can. The concern is, I understand what your concern is, but we focus on the activity, not the identity of the individual conducting the activity. And as Mr. Doima says, if there is a minor who is doing the activity, and Ms. Anderson indicated, you're really engaging in an educational activity with that minor as opposed to an enforcement activity.
And finally, if I may add to go to your question, Chair Gutierrez and Councilmember Sneddon as well, if there was a situation where people would see a minor almost being forced into this issue and vending, that would be something where it would be reported to the police department, and they would conduct an investigation. It'd really be outside the realm of vending. Yes, vending is the activity going on, maybe the labor or the work. And if there is criminal activity, obviously not on the act of the child, but whoever is putting the minor up to this issue, that would be something that would be outside the vending ordinance. It would be something that the police could investigate, and if there were activities, illegal activities, bring charges on. So that's something outside the realm of the vending ordinance. So I understand it could potentially be going on, but that would be a criminal investigation if minors are being coerced or pressured, forced labor, et cetera.
Yeah. I'm just having flashbacks of when I was a kid and I would sell chocolate bars or magazine subscriptions to raise money for my school or something, and whether or not there are people out there that will go as far as to start a nonprofit or something like that under the guise that they will be able to get away with certain things that we're trying to prohibit under that mindset, I guess you can say. So yeah, I don't know. I'm just trying to think of all the bases here and trying to avoid loopholes and exploitation of protected class if possible. Okay, that's all I have unless anybody else has any further questions. Okay, are there any public comment for this item?
Chair Gutierrez, we do have one individual who's raised their hand. Just to note, we have nobody in person making public comment, but our first online person will be Natalia Gavoni. Natalia, please go ahead.
Good afternoon, Chair and committee members. While I do appreciate these changes to the amendments, I still have some concerns, such as the valid ID requirement that Mr. Hensky talked about this afternoon. Does that include the seller's permit, health certificate from the county, certificate of liability insurance, vehicle insurance and current registration, and a copy of the route of these vendors? And if so, why aren't these vendors putting this type of documentation on the outside of their cart? Why are they having to be asked to produce it if somebody asks? It should be visible as those types of documents are visible once you enter a restaurant, or at least some of them are. My second concern is, why isn't the city of Santa Barbara not highlighting, but pushing for encroachments that many of these vendors do, especially on the Milpas corridor where I have a business located? I think it's very unfair that many of the residents have to walk around them on the street so they can continue these mobile food vendors to operate their business. And lastly, why wouldn't the city of Santa Barbara think about proposing a moratorium? The city of El Monte actually has proposed one. They also have pushed, and were very successful, pushing an encroachment policy to help cure this problem. Thank you.
Any other public comment?
Chair Gutierrez, we have no further public comment.
Okay, now I'd like to open it back up to my colleagues for any further questions, discussions, or motions. Councilmember Snowden.
Thank you, Chair Gutierrez. So I'm interested in some of those questions that were just raised. Are we requiring display of the permit or license? Or, if you're coming up to a vendor, how do you know if it's a legitimate operator or not?
Honorable Chair, members of the committee, what we're talking about in that particular context is a sidewalk vendor under the sidewalk vending, and our scope of our regulations is circumscribed by state law.
Okay.
Our existing regulations are as far as we can go under state law. If they're not a legitimate sidewalk vendor, they can't be out there at all.
Okay, thank you. So a member of the public wouldn't know, or, someone wouldn't know unless they asked, or, if I want a hot dog and I don't want to break the law, how do I know which vendor to go to?
Honorable Chair, members of the committee, the one that sells the best hot dog. You're really talking about health permit activities, and that's enforced by the health department, not by the city.
Okay.
And I'd also add too, in terms of the other license and all that, as Mr. Hensey said, we're following our parameters, the most under state law. If you remember the creation of SB 946, the legislative intent was to provide economic opportunities that were so underground and illegal everywhere, to bring it out in the open, and to not have vendors who depend on, survive on this, to have to be doing it in the shadows, to be able to do it in the open and not be fear of reprisals. That's why they eliminated the criminal penalties on this, et cetera. So it's not meant to be a difficult process because of the economic opportunities that the state said you need to provide. But again, cities, you can regulate when it comes to health, safety, and welfare. You can't do it again for economic competition, but you can do it for the purposes of health, safety, and welfare. So we are limited in terms of all other requirements and things they have to show or proof of insurance. We just have followed state law in terms of having a city business tax certificate, showing ID, and if you're selling food, having your health permit show. But again, enforcement on that's for the county health, not the city.
I guess that's my question. It needs to show. If they have the health permit, it needs to be visible. Okay.
Honorable Chair and Councilmember Snedden, you can request, it needs to either be on their person or posted,
Okay.
their county public health permit.
And then I'm assuming that the pedestrian right-of-way question, encroachment, that also is regulated by the state?
Honorable Chair, members of the committee, under our existing code, there's different regulations for a stationary sidewalk vendor and a roving sidewalk vendor. a stationary sidewalk vendor is not permitted to block the travel lane. So a mobile sidewalk vendor, you don't have the same issue because they just, they get their cart out of the way.
And just move, okay.
Right.
Thank you for entertaining all these questions. I know
Sure.
it's, there are a lot of them. So I'm in support of these amendments, and those are my comments.
Thank you, Councilmember Sneddon. Councilmember Jordan.
Me too. It's just, the world's not my parents' world. That's why we got to go through this misery, right? So I'm particularly happy to see the ID requirement. I know everybody's been frustrated with going out and trying to do enforcement action. Nobody really has to say who they are or can't say who they are. And I'm doubly excited about then the impound ability, because we need to have a hammer when people just essentially blow us off. To the extent that you ever want to do some more work on this, I just chafe under if we're out looking at our street for our ordinances and it's obvious that there's no posted, whatever the county permit is, that our inability then to say you don't meet the requirements to work in the city of Santa Barbara under our ordinance. I just wish we had that ability. I mean, we don't have to determine, do you have one sink, two sinks? We don't have to determine, can you wash your hands? It's predetermined by the county by having some little thing posted that's in every restaurant that you or I go in. And it just seems unfortunate that we can't do the work to make it that simple, that you come play fair, and if you play fair, according to our ordinance and what other restrictions other agencies put on you, great, but we don't have to determine if it's fair or not. You just have to have that posted to move forward. So I think this is great. Move it forward. I'll make the motion to forward this to council with our recommendation.
Okay, let me just give some comments. I too want to move this forward. I would just ask that you look into how having minors be the solicitors will affect this, and also nonprofits and religious institutions, just to make sure that we have enough input on this issue before it gets to the whole council. So with that, if we can have the motion read back to us, please.
Moved by Councilmember Jordan, seconded by Councilmember Sneddon, that the Ordinance Committee consider an ordinance amending the Santa Barbara Municipal Code by amending Chapters 9.48 and Chapters 9.49, by repealing Chapters 5.32 relating to peddling, soliciting, and vending on public and private property. We'll go ahead and take a vote.
Okay, that passes unanimously.
But you put yours in, right? It came up green.
Yeah.
It did. Okay, but it passed unanimously, so thank you so
Okay,
much.
and with that, unless there's anything else, I'll adjourn this meeting.